Hello everyone and welcome to today's Mondac webinar in association with William Fry. This webinar will cover how liability law is adapting to technological advances with insights from key experts. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Before I hand over to Mary and the panel to begin today's webinar, a housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. They will endeavour to answer as many questions as possible during our Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Mary to begin. Thank you.
Thank you, Dan. Good afternoon, everyone, and thank you for joining us. I know we have people joining from all parts of the world and various time zones, so welcome everyone, and I hope it's not too early or too late wherever you are. My name is Mary Cooney. I'm a partner in William Fry in our litigation and investigations department. I specialise in healthcare and product liability, and so I'm really delighted to be hosting this webinar today in areas which are of huge interest to me. I'm joined by my colleague Barry Scannell, who's a senior consultant in William Fry specialising in AI. We are really delighted to be joined by our two guest speakers today, and I'm very grateful they accepted our invitation to be a part of this webinar. Firstly, Omar Naji, who's a legal and policy officer with the European Commission and a member of the group that is drafting the proposed new Product Liability Directive. We're also delighted to be joined by Axel Voss, MEP and rapporteur for the AI Act and the AI Liability Directive. It goes without saying that we're really looking forward to exploring these proposed changes and this proposed legislation in Europe with our guests, who undoubtedly have some really valuable insights from being at the coalface of drafting this legislation. The running order for today is I will speak first about the Product Liability Directive and the proposed direct changes that the revised directive will bring about in Europe. We'll then hear from Omar Naji, who will give us his insights on the new revised directive, the incentive for change, some history and rationale behind the proposed changes, and input from industry and stakeholders to these changes. We will then hear from MEP Axel Voss, who will provide his insights on the AI Act and the impetus for the introduction of this legislation, and insights and opinions from a European perspective. Finally, we'll hear from my colleague Barry, who will be discussing the key aspects of the new proposed AI Liability Directive. We then hope to have some time for discussion amongst the group and a quick Q&A. So without further ado, I will begin with our discussion on the proposed Product Liability Directive. So the current Product Liability Directive was enacted in 1985, and with the exception of some amendments in 1999, it has broadly remained the same for the last 38 years, which is remarkable really. However, over the past number of years, we've seen a tsunami of emerging technology, not only in consumer products, but also in medical devices. And it was only a matter of time really before it became necessary for legislation to try and catch up with this digital age. For example, we've also seen the implementation of the Medical Devices Regulation in May 2021, which replaces a directive enacted in 1993, and the In Vitro Diagnostic Medical Devices Regulation enacted in May 2022, which replaced the In Vitro Diagnostic Medical Device Directive from 1998. The new legislation, which we'll be discussing today, will ensure further protection for consumers and patients. From a practical perspective, we would all have seen huge innovation by companies during the COVID years, creating new products or pivoting and adapting their existing products as a result of the pandemic and the resulting restrictions in place across the world during that time. For example, the exponential growth in online commerce, an increase in remote medicine, not just telemedicine, but with medical device companies creating apps so patients could be monitored at home, and even companies trying to help, such as 3D printers making PPE. So the Product Liability Directive, when enacted, was intended to harmonise product liability laws across Europe, but it did leave some flexibility to member states in its transposition. It is transposed into Irish law by the Liability for Defective Products Act 1991. The directive and the 1991 Act established that where a consumer can prove, in the absence of limited exonerating circumstances, the existence of a defect, resulting damage, and a causal link between the damage and the defect, strict liability will be imposed on the manufacturer or, in certain circumstances, the importer of the defective product. While it is broadly accepted that the directive applies in principle to products incorporating AI, It falls short of adequately dealing with the complexities of these products due to advancements in digital technologies and how AI affects the operation of products. For several years, the Commission has been working on an initiative to adapt product liability rules to the digital age and AI, which I'm sure you'll be hearing more about from Omar. Following a public consultation on the topic, on the 28th of September 2022, the Commission adopted 2 proposals for directives, one on liability for defective products and one on AI liability, which Barry will be speaking to you about later in the webinar. So I'll briefly run through, by way of refresher, some of the key definitions in the current Product Liability Directive. So damage is currently defined as damage caused by death, personal injuries, and damage to or destruction of any item of property other than the defective product itself. Regarding property, this is limited to property intended for private use or consumption and used by the injured party as such. There's also a minimal threshold of €500. Product is defined as all movables with the exception of primary agricultural products and game, even though incorporated into another movable or into an immovable. A product is defective then when it does not provide the safety which a person is entitled to expect, taking all circumstances into account, including the presentation of the product, the use to which it could reasonably be expected the product would be put, and the time when the product was put into circulation. A product shall not be considered defective for the sole reason that a better product is subsequently put into circulation. Something that producers will be aware of, they can be cleared of liability under certain conditions, notably if they prove that they didn't put the product into circulation, the defect was due to the compliance of the product with mandatory regulations issued by public authorities, and the state of scientific or technical knowledge at the time the product was put into circulation could not detect the defect. So moving then to the new revised directive. So how might this existing framework change? So the revised directive seeks to modernize liability rules for circular economy businesses so that economic operators who make substantial modifications to a product can be liable when these modified products are defective and cause damage. However, they may also be exempted from liability if they can prove the damage is related to a part of the product not affected by the modification. Compensate for damages for products incorporating AI are made unsafe by software updates or services needed to operate the product, as well as the failure of the manufacturer to address cybersecurity vulnerabilities. Ensure there will always be a business in the EU that will be liable for harm caused by unsafe products, even when the product is imported from outside the EU. Where there are no EU importers or authorised representatives to sue, the revised directive allows for claims to be brought against fulfilment service providers, which involves warehousing, packaging, addressing, and dispatch services. And provide a level playing field for consumers and manufacturers by requiring manufacturers to disclose evidence, introducing more flexibility to the time restrictions to introduce claims, and by alleviating the burden of proof for victims in complex claims. So then if we take a closer look at some of the definitions under the revised directive, the proposed directive does seek to encourage the rollout and uptake of new technologies, including AI, and ensure at the same time that the consumers can enjoy the same level of protection irrespective of the technology involved. The definition of damage under the current directive, as we've seen already, includes damage caused by death, personal injury, and damage to property. The definition has now been extended to include medically recognised harm to psychological health and loss or corruption of data that is not used for professional purposes. The definition of product, the revised directive confirms that software is a product for the purposes of applying no-fault liability, irrespective of its supply or usage, and even where it is stored on a device or accessed through cloud technologies. It also expressly provides that developers or producers of software, including AI system providers, should be treated as manufacturers, thereby bringing both software and software developers unequivocally within the scope of the revised directive. The minimum threshold of €500 has been removed, and the revised directive, as I've said previously, maintains a position regarding liability exemption for manufacturers where they prove that it's probable the defect that caused the damage did not exist when they placed the product on the market or put it into service. However, the revised directive also provides that manufacturers will be liable for defects that occur after the product is placed on the market or put into service because of software or related services within their control in the form of upgrades or updates or machine learning algorithms. Liability also extends to manufacturers where a defect consists of the lack of software updates or upgrades necessary to address cybersecurity vulnerabilities and maintain the product safety. In terms of the burden of proof, injured persons must prove damage, defectiveness, and establish a causal link between the defect and the damage. In order to facilitate an injured party's access to evidence, which is required to investigate, prove their claim, the revised directive requires manufacturers to disclose how a product was produced and how it operates, with appropriate protections put in place where trade secrets are involved. If this obligation has not been complied with, the national court should presume the defectiveness of a product. Furthermore, the revised directive introduces rebuttable presumptions of fact to alleviate the consumer's evidential difficulties. So in cases where it would be excessively difficult for the consumer to prove defectiveness and or the causal link, and where requiring such proof would undermine the effectiveness of the right to compensation, national courts should presume the defectiveness of the product and or the causal link, irrespective of the defendant's disclosure of information. As such, given that manufacturers have expert knowledge and are better informed than the injured person, it should be for them to rebut the presumption. The factors to be considered here include the complex nature of the product, such as an innovative medical device. Finally, under limitation periods, the revised directive maintains a 10-year liability period post-placing on the market for producers of defective products. However, consumers enjoy an additional 5-year period of cover in cases where symptoms of personal injury are slow to emerge, e.g. on ingestion of a defective chemical. This effectively increases the 10-year limit to 15 years. Further, the point at which the clock starts to run may differ in cases where a product has been modified substantially outside the control of the original manufacturer and is considered a new product. In such cases, the 10-year limit is triggered at the date of the substantial modification rather than the date it was originally placed on the market. So a lot of changes there, a bit of a whistle-stop tour, but we can see why it was necessary to introduce a whole new directive rather than try and amend the 1985 directive. Undoubtedly, this new directive is bringing the governance of product liability into the digital age. I think personally, from a legal perspective, it's often only when legislation is enacted that certain clauses end up in dispute between parties in litigation, and it's when these are argued out in court and a decision handed down that we really begin to see how the legislation will evolve and operate in practice. Some areas I would be interested in exploring further are perhaps the interaction of this new directive with the AI Liability Directive, the interaction of this with the new Representative Actions Directive, which I think is due to be enacted in June 2023. And I think some commentators have some opinions on that regarding an increase in class action claims, particularly with the removal of the €5 minimum threshold. And also, I think another area that might be different between various member states is what is a medically recognized harm to psychological health. So I'll hand over now to Omar, and I look forward to hearing his views and insights on this new directive.
Thank you, Mary, and thank you everyone for the invitation. It's always a pleasure to speak and present this long-time project. I mean, it has been 40 years, and I think it was probably time, as you rightly explained. And I think we can go directly on the next slide, and also to show a bit how the product liability is the current product liability, but also the proposal in itself. As you can see, the PLD, it's larger than any other type of legislation, and it's different from the safety legislation themselves. Safety legislation like Machinery AI Act, GPSI, etc., are sectorial products, and they are specific to type of product. The product liability enters into action when there is something wrong that happened, when there has been a damage and a victim is seeking compensation. And this also explains why we kept let's say, the technological neutral approach of the PLD, because each provision has to work in the same way for an AI system, but also for a toy, but also for food, or also for a table, and etc., etc. So the rules have to be flexible enough to work for this. But at the same time, as you said, we needed to adapt those rules because in 85 products were not the same, and so there has been evolution to that. Next slide, please. So what was the aim of the revision, let's say in general? We looked at what was working in the current regime, and we did not want to touch what was working. So as you explained, there are fundamentals in the PLD, and those are kept as they are. The manufacturer is liable for damage caused by a defect in their product, and the injured person is the one that bears the burden of proof. He has to prove the damage, the defect, and the causal link between both. These are the fundamental principles of the PLD that have been maintained, and the only things that the revision tried to seek is to clearly readapt some of those elements without touching to the balance that has been put in place in 85. So as you've explained, obviously we have changed some or put some clarities on who's the manufacturer and when can it be liable for what type of damages, but without changing the purpose itself of the directive. Next slide, please. So we had 4 aims in the revisions: to adapt to the digital age, because we have to recognize that products from 85 have evolved and we have now new technology, but we also needed to adapt to what we have now in the circular economy. There have been many questions from manufacturers to know, well, if someone else changes my product and makes it a business out of it, would I still be liable for a defect in this product or not? So these were clarities that we tried to find and try to adapt to it. But then there was the other question about the global value chains. In 85, we knew the manufacturer either could be outside of the union or in the union. We had the importer, and we had distributors or suppliers. We didn't have any other type of, let's say, figures or economic operators. But now this has changed. Through all the safety legislation, we have new economic operators. Take the market surveillance regulation or the GPSR, we have included authorized representative fulfillment service providers. There is also the question of online marketplaces when they only intermediate the sales between the trader and the consumers. All of these figures needed to be included and readapted to ensure that there is always someone liable in the union for any product that is brought in our market. So that was an adaptation. And the last one, and this is where what we usually call a codification of case law, we tried to look at the 40 years of practice across the union and through the Court of Justice judgments to see where there were issues when it comes to the case itself. So this is mainly about the burden of proof, but then also what we call the asymmetry of information between the victim and the defendant. So these were the main, let's say, aims of the revision. Next slide, please. So when we talk about the adaptation to the digital age, I think that we need to clarify some points about this revision. The revision or the proposal does not extend the scope of the PLD. The PLD has always applied to all products. In 88, there was a question to, back then, the Commissioner for Internal Market and Consumers about to know whether software was a product. In 88, the reply from the Commission was clear. Software, like any other product, are products. So the debate was not that there were unclarities because obviously the wording of the definition of product, meaning all movables, was a bit unclear for that. But that was just a clarification, and this is just a clarification. All software are product and therefore also AI systems. I mean, as you rightly mentioned, in the medical device regulation, it recalls that medical device can either be software, like we call the embedded software or the standalone software, and that the PLD applies for the liability when something goes wrong with a medical device. So the current PLD already apply to any type of product. So that's a bit of the situation. Same for the machinery, etc., etc. And if you take now the AI Act that is negotiated in Council and Parliament, the AI Act clearly says that any type of AI are products. So when the safety legislation clearly tells you that they are products, the safety net that the PLD is has to encompass all of them, because the PLD has been created to ensure that when a product, even if you comply with the safety obligation, causes damage, there must be a solution for the victim to at least have access or to ask for compensation. But once we say that software are in the PLD, there are questions that are related to that. And this is where we have included, and this is a novelty, the digital services or the related service. Because as we know, software don't always work alone. They can work with someone outside, a third party that provides a service to that software to make it work. So what we have included is what we call the related service. When a service is necessary for the product to function, this is captured as a component of the product itself. So for instance, you take an autonomous vehicle that requires a continuous input of data from a third party. Under the current PLD, you would have the question to know whether this is something part of the product or not. So we extended here the liability to those third parties when the related service has been integrated by the manufacturer of the product itself. So you, as a manufacturer of an autonomous vehicle, you put a car on the road and you make sure that your software requires inputs of data from a third company. Well, the third company would become then a related service, and then it considers a component could be held liable if there is a defect in this element. So this is a novelty. That is an addition. Obviously, there is the question about open source software. What happens when an open source software was put on the internet and a manufacturer decided to take it? Would you be still held liable or not? We clarify obviously that if an open source software is outside of commercial activity, and I have to stress that any product that is outside of a commercial activity is not captured by the PLD. You need to be in a commercial activity, but that was a needed clarification. But if a manufacturer takes an open source software that is outside of commercial activity, he can be held liable if the open source software is found defective and has caused the damage. But the developer of an open source software outside of commercial activity cannot be held liable. That's a bit of the difference. And obviously, you make liable the person that has integrated this element. Then we come to the part of the adaptation of the rules when you say that any products are under the PLD. As you explained, there is a defense in the PLD that says that the manufacturer, if he can prove that it's probable that the defect was not there at the moment of placing on the market, then he's not liable. We maintain this exemption. This is one of the fundamentals of the PLD. It worked. It was essential to ensure that any changes made by people outside and therefore created a defect after placing on the market could not trigger the liability of the manufacturer. But at the same time, you need to be realistic. We know that a software can be updated. So therefore, you can add a defect by the manufacturer itself in the product even after it has been placed on the market. And there we have simply said that you cannot rely on the exemption, because it would have created just a circle to say that, oh, I have introduced a defect, but actually was after the placing on the market. So this is the only thing that this exception does. It does not require the manufacturer to update. It does not require the manufacturer to not update. On the contrary, it's just to say that you cannot use the exemption whether the defect came after or was introduced by your software update. And that's a clarity, because we have been asked quite often whether this is a new obligation compared, for instance, to the CRA, for instance, that is still at the proposal level, where introduced obligation. The PLD does not impose any obligation. As a manufacturer, you could also decide not to update, and your liability would be triggered because of another reason, not because you didn't. because you knew that there was a defect, or you have introduced a defect through an update. And this is limited in the 10 years time. That's a bit of the elements for the digital age. For the circular economy, it's a bit shorter, but it's still an important element. We didn't want to target a specific way of, let's say, changing products, saying, oh, refurbishment or remanufacturing, etc., etc. We tried to place a threshold saying that in the safety legislation, we recognize that substantial modification require to do again a safety check of your product. This is safety obligations under the safety legislation. Well, we said under the PLD, if you fall under this type of substantial modification, meaning that your product has to go again through a risk assessment, well, then this is a new product. So whoever does this substantial modification becomes the manufacturer. It sounds pretty clear that it shouldn't be the original manufacturer to carry on the liability just because someone did such a change that now it's a new product, but there is still the trademark on it. So that's an element that we have introduced. Next slide, please. For the global value chain here, it's really a clarification and really an introduction of what it is, who are the liable person. The main objective is to say that the victim needs to find someone in the union against whom he can go. And the reason are pretty simple. It's quite complicated to go against a manufacturer that is outside of the union because of the recognition of the judgment. Those kind of elements become really tricky and complicated. But that does not mean that the manufacturer outside of the union is not liable anymore. He is still liable, but we just give the possibility to the victim to go against people that bring the product in the union. So in the same way as in 85, we recognize that importers should bear the liability for the manufacturer outside of the union, we did the same. Authorized representative, fulfillment service providers are the ones that bring the product in the market. We have created a cascade, obviously. You cannot just pick and choose the person. It's importers and authorized representative. And if none of them are in the union, then it's the fulfillment service provider. And then we come to the distributors and what we call the online marketplaces. In the general rule of the PLD, the supplier needs to tell to the victim who is the manufacturer, if there is a manufacturer in the union or not. If there isn't a manufacturer in the union, he bears the liability for this manufacturer. This is how the current PLD works, and we have kept this element. But we had to, let's say, do the same also for online marketplaces, because it happens in some instances where there is no one else than the online marketplace that has brought the product in the union. But in this case, we have aligned with what exists already under the DSA. We want to keep coherence. So we have maintained the same liability exemption of the DSA. And we just recall that when there is no exemption under the DSA, so meaning that there has been this impression of acting like a distributor, let's put it in short terms, the online marketplace could be held liable. But it needs to be in the specific situation where none of the manufacturer, importer, authorized representative, fulfillment service providers are in the union. So it's really a last situation case. Next slide, please. And so finally, we come to adapting and making it easier and full compensation for victims. So, I mean, here it's a lot, it's new elements, that's for sure. But this is because through the impact assessment, through the study that we carried on, we've seen that there are many issues when applying the PLD. As we said, the PLD still puts the burden of proof on the victim. But sometimes it happens that actually it is so complicated that the victim can not prove the causal link or the defectiveness of the product. In those instances, we have introduced a presumption. Those presumptions are rebuttable, meaning that the defendant can always prove the opposite, but they are there to help in certain situations. Obviously, I'm not going to go along all of them, but maybe the last one that is the most interesting one. This one comes from directly the Sanofi case law from the Court of Justice, where the Court of Justice explained that in excessive difficult cases, and here I want to emphasize difficult cases, not products, the victim can have an alleviation of the threshold for the burden of proof, of the standard of proof. The only thing that we did is to put this presumption back in the PRD and to ensure conformity across all member states. And as I said, this applies to cases, not to product. So if you are in an AI, it's not because you have an AI product in the case that the product becomes complex. So it's really left to the judge to decide on the complexity of the case itself, but the victim needs to demonstrate that there are those complexities. So that's a bit of the situation. There is no automaticity in applying the presumption. The judge is the only one left, and we didn't want to impose anything to a judge because he's the only person at the end of the day that can decide exactly on the merits of the case. And then we come to the threshold, and I think here a bit of a element. The threshold was applied differently across all member states. Let's say that there were 7 of them. I'm not going to tell all of them, but there are 7 of them that were applying the threshold like an insurance threshold, meaning that if your case was above 500 euros, so let's say 505 euros, you would remove 500 euros from the compensation. And in some other cases, you would get the entire 505 euros as compensation. And there we've seen that there was a kind of discretionary element, because why would you compensate a case of 501 euro and why not 499 euros? The only thing is that this discretionary element actually created that victim would use other liability regime. So instead of reducing it as some people thought this would do, it actually put the problem in other liability regimes where there is no harmonization at union level. So what we wanted to ensure is like that the framework and let's say the main road is chosen as the PLD. So the 500 euros, which is a total discretionary threshold, should be removed. So at least that we have people using the PLD in the same way across all member states, instead of using all the strict liability regime that exists. So that's the choice. Let's say the consultation also showed us that there were roughly 80% of the consulted stakeholders that were against this. There were questions also about the compatibility with the Human Rights Charter and etc. So there were some elements that had to be taken into account because this would have posed some issues. So that's a bit of the rationale. And for the disclosure of information, and here just to clarify a bit, the disclosure of information is not a pre-trial. We're not introducing the discovery procedure that are known in the US. This is an in-trial disclosure of information when you started a claim under the PLD. Nothing else. So this is not a novelty. We're just trying to ensure that the same rule for disclosure in the process or in the case are the same across all member states. That's really a purpose of harmonization and legal certainty for victims, but actually also for defendants and manufacturers in general. They know what are the rules that will be used against them, and not 27 patchworks of rules. I'm going to end it here. Thank you very much.
That was great. Thank you very much, Omar. That was really interesting and great to get some insights from someone who is really at the coal phase, as I said, of the drafting. So I'll hand over now to Axel Voss, and he's going to speak to us about the AI Act.
So thank you, Mary, for the introduction. And so why we are coming up with an AI Act. So we are seeing algorithms have a lot of chances and a lot of risks, and so now we would like to mitigate the risks somehow, but not to hinder at least innovation. So this has been the intention of these. Also the question how European citizens of the society should deal with algorithms and how we would like to implement here human rights and environment, and in specific cases also rule of law and democracy, because algorithms can also undermine rule of law or undermine the democracy. So that's why we need here some rules in place. The intention is also, that's why we're coming up with the regulation, a European regulation, that we have harmonized rules throughout the single market and sometimes going beyond these. But so we would like to show rules for everyone who is dealing with a kind of in a legitimate way with algorithms. So this is the intention of this piece of this proposal of legislation. So what is important to look at it? So what we are doing is we have more than less 4 categories of risks, if you would like to say so. So the baddest ones are, or the worst ones are the forbidden ones. What we do not like is a kind of going forward, like for instance, the socializing or these social profiling like a la China. So this is what we totally do not like. We have some other cases also in these, but here we have political differences. So if we are coming to predictive policing, or if we are coming to emotional recognition systems or biometrical systems, here we have some ideological approaches on it, where in saying we have to ban. But our approach would more be, but now we are coming forward with a compromise in it, and we are carrying this compromise so far as an EPP group, that you can more differentiate. So every digital tool, you can use it for the good and for the bad, but to find the thin line between both, this would be something what I would consider would be the best way forward. But so now we are banning everything, what I do not consider is the right approach on it. But so this is the approach of the majority of the House. So in Article 6, of course, here you can see these high risk classifications. The proposal by the Commission was not, I would say, not broad enough, and so that's why we created, beside this critical infrastructure or critical sector, also the critical use, critical context. So if both is coming together, then we might consider these as a high risk system. But so this is also belonging to a kind of a self-assessment at the end for everyone. But also we have in Annex 3 these examples in saying what we like and what we do not like, and a little bit also here some specifications, what I mentioned earlier, regarding AI systems, what might undermine democracy or what might undermine rule of law. What we also integrated is a kind of a reference to sustainability. Also this one is somehow important, but we added also an element on sustainability or environmental issues, where I would consider this is too far going, because this has to do something with energy consumption and to reduce and so on, so that you have a kind of a less energy consuming algorithms, what you should develop. This is something what has nothing to do with regulating AI. This is more a kind of an environmental aspect, and structurally I would say this is not or should not be integrated, but we have this integrated also in the spirit of a compromise. So what is also important, just in between, the liability question is not integrated in this legal tool. So I do not consider this is very wise, but because we have here competence differences, because civil law is still a competence for the member states, but if you're asking me if it would have been better to integrate these already here and not fragmenting ourselves in a single market with different liability regimes, but this is something, and how I understood Barry is focusing on this element on AI liability better. What we also added in this Annex 3, and also this is something what there's a political difference in this. I would consider this should not be part of it, but the majority in our house said recommender systems should also be part of high risk, but focusing only on social media platforms, so that we can a little bit eliminate the situation where someone is saying, oh, you have watched this video, please watch also this one, and this might be also lead to misinformation or something like this. We would like not to have this seen as a kind of automatically doing something without being more aware that this misinformation might be spread if there is misinformation in it. So this is what we as an EPP group do not like, but it's in the text. And where we have a kind of an exemption, this is for research, this is for open source, and this is also for international private law. And what we also have had in mind, especially with the now upcoming discussion about ChatGPT, that we said, oh, also intellectual property rights should not be affected by AI models or AI systems like this. So meaning at the end, please respect intellectual property rights. And this is not a kind of an exemption to it. So this was a kind of a side aspect because of ChatGPT. And also for these foundational models or general purpose AI models, we have also an Article 28b in it, in saying, and I would more evaluate this in a way, this is a kind of a fair burden sharing. We do not put these into a kind of a high-risk sector or high-risk systems. We do not categorize these as high risk, but we said this, the fundamental approach with AI models might not be a high-risk one, but if someone is putting in addition something to it, then it might become an AI high-risk model, and herefore we have some rules, ideas in place. And also what we would like to have is also that also the developer of a fundamental foundational model, that he already knows that some requirements will be needed or some informations will be needed later on for someone who's then deploying a kind of a high-risk system out of it. So what is also very important to have at first, of course, to train your algorithms, to test your algorithms, we thought about a kind of a sandbox system. And here, and I consider this extremely important, if we would like still to be part in AI developments in Europe, then we should have functioning sandboxes in place. Of course, sometimes we are exaggerating all these obligations and requirements and so on. But here we need to have something in place what is delivering data, or where you can test and train your algorithms also with personal data, what normally are not, might be allowed because of the GDPR. But here we have this interlinkage of GDPR and AI, because as a legislator, of course, we would like to have always a kind of a result out of it where we can say non-discriminatory, non-biased, and gender balanced, and so on. But to achieve these, you will need massively personal data. And here we are coming to this situation. If we do not have this data, we will never get kind of an accurate result out of algorithms. So that's why we think sandboxes are extremely necessary. This is a kind of an space where you can test and train, let's say, and this is in oversight by somehow officials in a way. But you can use then personal data without asking beforehand of the consent of the persons, so the individuals. So this is a kind of a very critical idea, and this has to be working, or this should be working in a way, otherwise Europe is somehow out of these developments. And we have had in mind two cases, companies who are coming with their own data and training and testing these, or companies who are very new one without data, and then we should provide also data here for training and testing. What we still should also have in mind, and here I think it's around Article 40, 41, it's very important also to have standards in place. So having in mind that Europe can provide to the world something in connecting values to technology, but not to making it too complicated to businesses at the end, we need to develop a standard. And then you should be sure also, if you're leaving a sandbox or if you are integrating the standard, then your algorithm is kind of secure regarding to all these requirements what the legislator now is implementing. And this is something where we are considering, if we once have developed a kind of a standard like this, then we might also move forward with these situations. So this is the idea. Of course, what we have also in mind is this kind of approach of trustworthy AI and what might be the requirements of it. So at first, we are putting requirements for the high-risk AI systems itself. And secondly, we have obligations for the providers or users of high-risk AI systems. And so we are putting a lot of requirements or obligations here, but from this discussion also with the business, it seems that this hasn't been a kind of a problem so far. Although this is, from my point of view, a very long list, but it seems to be achievable. So that's why we need to think about how we might act in a way that this is working and so on, and having these trustworthy AI in mind. This means also there should be a kind of a human oversight for high-risk elements, not for every AI system. So it doesn't need to be affected by every AI system. We need a kind of a technical robustness. We need a governance structure, transparency, and accountability in a way also in these developing. So, and here we are coming to this question of governance structure. What we are doing right now, we are asking for an AI office. So, we are explaining what this means, who is a member, and so on. And but having in mind that this approach in this mandate with asking for governance structures in the Digital Services Act, Digital Market Act, in the GDPR, we have had this already, now the AI Act, in the Data Governance Act. So having in mind that the AI office might be only a kind of a first step, in a long run, I would like to have, let's say, vision that we are all should emerge these governance structures to come to a kind of a very holistic and horizontal approach, that we are not having only data protection or only competition in mind. No, it's now we should come forward later. But this is a task for the next mandate, and you will never know where are the majorities are. So let's wait. But these are the most important points, and I hope I could give you kind of an overview.
No, that was fascinating. Thank you very much. Really gave me an understanding anyway of the complexities involved in trying to regulate something, the capabilities of which are still quite unknown, really. So yeah, it's tough job. I'll hand over now to Barry Scannell, who will be speaking to us about the AI Liability Directive.
Thanks very much, Mary, and thanks very much, MEP Voss. I was taking lots of notes there. I'm doing a PhD on AI and copyright. There's actually a chapter of my PhD on IP and why IP isn't in the AI Act, and that it maybe should be. And I found your comments around IP and the AI Act very interesting. Of course, I thought I was about to finish my PhD before Christmas, and then there was a bit of an explosion in AI that you may have, that the viewers may have been experiencing, and you know, it's absolutely shocking the speed at which everything is taken off. So if we could go to the next slide, please. So I'm going to be talking about the AI Act, and in particular, you know, the idea that this new technology brings with it new risks. And I guess, you know, with any new technology, new risks come along with it. And the idea behind the AI Liability Directive is to try and guarantee that individuals impacted by AI systems receive the same degree of protection as those affected by other technologies in the EU. So the new rules for handling liability concerns related to AI systems are part of a larger set of initiatives, and Omar and MEP Voss, you know, referred to them as well. And of course, Mary was talking about the Product Liability Directive, but we're seeing revisions, like, well, obviously we're seeing the AI Act, but we're the revision of the General Product Safety Directive, the Machinery Directive, and taking it into the wider consideration of all the other digital decade type legislation like the DSA, the Digital Markets Act, the Data Act, and all of these digital type legislation that began, I suppose, with the GDPR. So when it comes to liability and AI, the issue with AI is that it's what happens within that neural network. There's the idea of black box. And the idea of a black box when it comes to AI isn't the same as the idea of a black box that we're used to with airplanes. With airplanes, the black box tells you everything you need to know about what happens. But when we use the term black box for an AI system, it means we don't have a clue what's going on inside it. We don't know how the neural infrastructure within it is coming out with the outputs based on the inputs. And, you know, we hear about, for example, recommendation algorithms, and YouTube creators, for example, and TikTok creators are constantly trying to figure out what direction is the algorithm going on now, and trying to tweak their content so that the algorithm will favor them. But the truth is, even the people behind those organizations don't fully understand the direction those algorithms take sometimes. So we've had to develop new concepts around liability regimes. So the standard fault-based liability regime that we'd be used to is basically predicated on three factors. There has to be damage, there has to be fault of a liable person, and there has to be a causal link between that fault and the damage. Now, the issue with AI is that you might be able to show that you're damaged, and you might be able to point your finger at someone saying, well, it's their fault. But because of the sophistication of the technology, it's very difficult, potentially, for victims of damage to be able to prove that causal link. The idea behind the AI Liability Directive is to try and address that issue. And the reason it's being done at a European level, there's two main reasons: fragmentation and legal uncertainty. If it's not addressed at a European level, every nation within member states within the EU is going to start trying to address this in their own way, based on their own national liability regimes. And what you'll end up with is a fragmented liability regime throughout the European market. And what would that mean? That would mean that there'd be enormous legal uncertainty for any product containing AI features being introduced to the EU market. And that's not something we want, because like the basis of the EU at the end of the day is it's a trading bloc, and we want to ensure harmonized trading. And we want to ensure as well that as a bloc we're very innovative and that we can continue to innovate. So the AI liability directive seeks to address this issue. So it's interesting that when it was first being discussed, the European Parliament initially suggested establishing a strict liability regime for high-risk AI systems. And the high-risk AI systems is very much linked to the AI Act. And it's important to note that when we talk about the AI Liability Directive, that it's very, very linked to the AI Act and other pieces of legislation. And if we could actually go to the next slide, please. So, you know, when we talk about the definitions that are contained in the AI Liability Directive, it doesn't define AI itself, but it references, for example, the general concept of AI is in the AI Act, particularly around the definition of AI systems. And the new rules would apply to damage caused by AI systems, regardless of whether they are classified as high risk under the AI Act. So it applies to high risk AI systems, but also other types of AI systems. Now, it's important to recognize that we're talking about liability irrespective of a contractual link. So it's, you know, a tort-based approach. Now, the AI Liability Directive won't affect existing rules laid down under European legislation, particularly EU rules regulating conditions of liability in the areas of transport, proposed revision of the Product Liability Directive, or the Digital Services Act. So it's similarly to the AI Act, you know, even though in Annex 2 you have things like transport to machinery included in the list of legislation that would be considered as high-risk AI. For the most part, the AI Act doesn't apply to those because they're going to have their own specific esoteric pieces of legislation, because those are such regulated areas with such advanced regulations as it is. Now, when just coming down to what is a claim for damages under the Liability Directive, it's considered a non-contractual fault-based civil law claim for compensation. The damage must be caused by the output of an AI system. So one of the main features of the AI Liability Directive is this idea of a rebuttable presumption of causality. That issue that you have damage, you have fault, how do you tie them together? So Article 4 lays down a rebuttable presumption of causality, establishing a causal link between the non-compliance of the duty of care under an EU or national law, which would be the fault, and then the output of the AI system. So to be able to rely on that presumption of causality, there's a couple of conditions that must be met. So first of all, the claimant must demonstrate that the non-compliance with a relevant law caused the damage, and that's under Article 4(1)(a). Now, in relation to high-risk AI systems, this would relate particularly to their non-compliance with the AI Act. So, for example, have they not implemented, you know, proper data training, proper transparency, proper data validation, and other aspects that are required under the AI Act of providers of AI systems. And then with users of high-risk AI systems under the AI Act, it could be, you know, have they proper human oversight measures in place? Have they deviated from the, have they proper accuracy when it comes to using the AI systems? Then for non-high-risk AI systems, the presumption only applies where the court considers it excessively difficult for the claimant to prove that causal link. And the presumption of causality doesn't apply if the defendant proves that the claimant has sufficient evidence or expertise to prove that causal link. So the defendant can say, hang on, they can prove this without that presumption. You don't need to bring this in. So there are safeguards there. Secondly, it must be reasonably likely that based on the circumstances of each case, the defendant's negligent conduct has influenced the output produced by the AI system. So it must be reasonably likely that whatever the AI did or didn't do was influenced by the fault. And then finally, the claimant has to demonstrate that the output produced by the AI system or the AI system's inability to produce that output caused the damage. And that's something that has to be established by the claimant. Now, another aspect of the AI Liability Directive, and we're short in time, but this will be very short, is the idea behind disclosure of evidence. So for high-risk systems, the large number of people potentially involved in the design and development of high-risk AI systems make it really difficult for plaintiffs to identify, well, who is the person liable. So the proposed rules of the directive will give national courts the power to order disclosure of evidence about high-risk AI systems that are suspected of having caused damage. Now, similar to GDPR, this will be about a balance between the rights of victims of damage and the right of these businesses to conduct businesses. So the court will have to take into account proportionality, and they'll have to take into account the business's rights to confidential information, trade secrets, and so on. And it'll be really interesting to see how that plays out in court, because AI algorithms are absolutely everywhere now. And what's important to note about this disclosure of evidence is that it applies to third parties as well. It's a third party disclosure, but it must be necessary and proportionate to support that claim for damages. So we're a little short in time. I'm going to finish up there. Hopefully that was a good run through for you about what's coming down the pipes with the proposed AI liability directive. And if we've time for questions, I'd love to field them.
Sorry, Mary, you're on mute at the moment. Thank you.
I think I'd realised that after 3 years of Zooms and webinars, remote talking. Thank you, Barry. I was just saying that was a great whistle-stop tour, so really appreciate your insights on that, especially when I know you're so familiar with the AI Act as well. I have 1 or 2 short questions I wanted to just ask our speakers while we have you here. But particularly, I suppose, with the AI Liability Directive and the Product Liability Directive, do you have any idea when these might be enacted or when we can expect to see these finalized?
So the AI Liability Directive, what I would personally consider we should make a regulation out of it. Because of the ending mandate, I do not see this coming to an end in this mandate. So meaning this will be part of the next mandate, and this means this is starting 1st of July next year. But what we can do is a bit work on this AI Liability Act, and probably we might start to negotiate a bit already in July, but we have to see how the AI Act is going forward.
And I think I can reply for the product liability, although it also concerns Mr. Boss. The product, I mean, in council we are working pretty fast, and the parliament is also doing a great job. I mean, we are quite amazed by the interest and the serious of the co-rapporteur, but also the entire parliament. The 2 committees are involved. It was a bit later because of how the entire institution works, but finally we can hope to have something by the end of the year. So that's a bit of the situation now, but almost 100% sure that it will be enacted by the end of the mandate as well.
Great.
Yeah.
Good news. And I know we are short of time because we all I guess we all had so much to say on our respective areas, and it was quite a tight time slot. But does anyone else, or Barry, do you want to ask anything else before we wrap up? I'm sure anyone from the audience is free to email us afterwards if you'd like to send in any other questions. But
Mary, to be honest, I want to ask so many questions, and that could take up the rest of the day, literally. So I'll leave it for another time. I found it fascinating, and even though it was a panelist, I took so many notes myself. It was great to have MEP Bass and Omar on today.
Yeah, and just on my behalf as well, thank you very much, MVP Voss and Omar, for joining us. We really appreciate your insights, and you're clearly so knowledgeable in this area. So yeah, it was fascinating to talk to you, and I wish, like Barry, that we could talk to you a bit longer, because I have loads of questions I'd love to discuss myself. But I know you both have busy days and other things to attend to, so we'll wrap it up there. But thanks so much for everyone else for joining us. We hope you all enjoyed the webinar today. It is recorded, so it's available for download afterwards for anyone who's registered. So if you want to watch it back again in your spare time, you can. Okay, thanks everyone.
And thanks so much to follow that as well for